folks, and welcome back to Contract A. This is week 3 of our unit, and this week we are looking at the second of our contract prerequisites. Last week, number 1 was intention to create legal relations, and this week we are looking at capacity to contract. So let's jump into our Prezi. Well, why on earth look at capacity to contract? If you think back to week 1 when we had a little look at theory, and yes, I'll be referring back to that at odd times throughout the term, we learned that a contract needs to be the result of a meeting of the minds, in that it has to be the free voluntary will of the parties. And we had a look at will theory, promise theory, consent theory, and in amongst that notion of a contract being the free, voluntary or independent will of the parties, obviously, firstly, you have to intend that the contract's going to be legally binding. Firstly, that's what we did last week. But implicit in all of that notion is also you need to understand what it is that you're about to do. Okay, you don't necessarily have to have an appreciation of all of the fine detail of what the contract says, but certainly you need to understand the general nature of what it is that you are contracting to do. And so that is where the prerequisite of capacity to contract kicks in. It's all about ensuring that the parties are equipped with a sufficient knowledge or understanding of, the general purport of what it is that they're going to do. There are 2 main areas that the courts have had to consistently deal with where questions of capacity have arisen over the years, and they are the issue of minors and people with some form of mental incapacity. So they are the main areas that we are going to be looking at today. Firstly, as to minors. So it might seem a bit strange for you young whippersnappers that have been brought up in the modern era to hear us talking about minors. Most of the talk nowadays tends to be about underage people, underage drinkers, underage offenders. But minors is the kind of technical term that we tend to revert to in law. And a minor is anyone that has not yet attained the age of majority. Slightly antiquated language there, but it just means anyone that's under 18. What legislation tells us that? And yes, this is set in legislation. It's all of the state and territory legislation that deals with this issue, and you'll find the names of the legislation in the text. Most of the various bits and pieces of the legislation are called things like, the Age of Majority Act, or, Minors and so-and-so, other things Act. So you'll see the names of the legislation in the text if you need to look that up. However, notwithstanding that we do have pieces of legislation in this area, it tends to be governed by the common law. Some of the state and territory legislation has changed things a little around the edges, some states more than others, but generally speaking, we need to still be familiar with the common law, because the legislation really just tinkers around with it. It doesn't really change it wholly and solely. So what's the general position? The general position is that contracts with minors, generally speaking, won't be enforceable against the minor. However, there are some fairly narrow exceptions, and if the circumstances meet the qualifications for those exceptions, then the contract will either be binding, just binding, no questions asked, or binding unless repudiated. So let's have a look at those. First, we start here with the general position. Contracts not binding against minors, generally speaking, just across the board. You can't enforce a contract with a minor. The only way that you can is if 2 things happen. Firstly, the minor turns 18, attains their majority, and secondly, they ratify the contract. That is, they have to take some step, do something that affirms that they accept the obligations contained in the contract. However, on the flip side, the minor can enforce the contract against the adult. So go minor. The other thing is too that these contracts, they are effective to transfer property. Now, I'll talk about restitution and restitutionary claims in this area in just a minute, but you should also note that the legislation has some bearing on that proposition there, when and how property is transferred and the ability to claim property back under these kinds of contracts. So the general starting position, you're not going to be able to enforce a contract against a minor. They can enforce it against you, however. Next step. Some contracts will be binding, and you've only really got to have a brief look at your study guide, or more preferably the text, to realise why this is. Very narrow circumstances where the contracts will just be binding across the board, and they are contracts for necessaries and contracts for employment or apprenticeship. In terms of necessaries, of course, a minor is going to be able to make a contract, for example, to purchase food. They've got to live somehow. So contracts for an infant's benefit and relating to the infant's person. Necessaries, food, clothing, lodging, that is premises, a place to stay, a place to sleep. Contracts of marriage, interestingly enough, and contracts of apprenticeship or service. They were all mentioned in the case of Cohen and Neild. Now, the test that you've got to get your heads around here is a two-part test. The first part is a question of law. The second part is a question of fact. Okay, so the first part says, is it capable of being a necessary? Is this thing that the minor wants to purchase, or services that the minor wishes to purchase, is it something necessary for that minor's person? Is it beneficial and necessary for their person? The plaintiff that wants to uphold the contract has the burden of proof of showing that this is so. Now, this is a question that the judge has to decide. And for the second part, you have to show that in these particular circumstances, this particular minor, this particular contract, these goods or services, are they actually required by the minor? And that will be a question of fact that goes to the jury. In terms of whether a necessary is capable of, in law, being classed as a necessary, has to be services or goods. If it is goods, then the sale of goods legislation will apply to that particular transaction. And that legislation provides that if necessaries are sold and delivered, then the minor has to pay a reasonable price. Sold and delivered. Minor has to pay a reasonable price, okay? Because remembering that in all circumstances, it needs to be contracts for an infant's benefit, okay? It's not going to be to an infant's benefit if they've contracted to pay an unreasonable or extortionate price, okay? So sale of goods says if they're sold and delivered, reasonable price, sorry, you've got to pay even if you're a minor. But remember, in amongst all of that, that the goods have to be necessaries, okay? So they have to be for the minor's person, usually goods like food, reasonable clothing, places to sleep and so forth. So where you've got ostentatious things that are being bought by the minor, no judge is going to say that they're necessary. So in Ryder and Wombwell, you've got this pair of jewelled solitaires and an antique goblet being presented as necessary. No. The next thing that you need to look at is a question of fact. And here is where your case analysis comes in. And a lot of these cases you will see, interestingly enough, tend to span from the 1850s through to about the 1950s, maybe 1960s. Seems to have been a very active time for the law growing in this area. I guess as contract was growing in as a whole, and also the law of torts was growing as a whole as well. And courts really had an eagle eye out particularly because torts really was in its infancy and contracts was a little further ahead. Courts did find some responsibility, I guess, in terms of protecting minors from what they would call catching bargains. The predators out there that wanted to prey on the minors that fell into their wicked trap of whatever they were trying to sell them. So in Nash and Inman, we have the plaintiff's traveller had met with a student at Trinity College at Cambridge, I think it was, and the word had gotten around that this poor kid was spending money pretty liberally. Woohoo, opportunity knocks. They managed to sell this poor kid 11 fancy waistcoats in about 9 months. I don't know how you would wear out a waistcoat per month, but got him into this contract worth more than £120, I think it was. So it was quite a lot of money for those days. 1908 this is. Was a bunch of fancy waistcoats necessary in the circumstances? No, obviously not. Again, courts have got one eye on this fact that each contract, if they're going to hold it up, has to be for the infant's overall benefit. Okay, the burden has to be proportionate to the benefit, and in fact the benefit has to outweigh the burden. So in Saltman and Bond, where a young minor had gotten themselves engaged to be married, wanted to buy a house, construct a house for, the proverbial white picket fence, blah, blah, so that they could have kids and raise their children in the house. The question was whether the materials and labour were, the contract for materials and labour was enforceable against the minor. And in that case, no, the benefits did not outweigh the burdens. And the burdens, as you will know, if you've ever built a house, are fairly significant. Extreme cost and time involved in those kinds of contracts. And the court said, no, sorry, the benefit here, not necessary for this particular plaintiff. So that's contracts for goods and services that fall into this category of being necessaries and satisfy the two-pronged test. What about the next circumstance of contracts for employment? Sometimes they are called beneficial contracts of service or articles of clerkship. Sometimes they're called indentures. Why on earth would they be enforceable against a minor? Pretty obvious, really. Hamilton and Lethbridge said it best. It's the means of maintaining themselves, so therefore they are not allowed to destroy the contractual basis for maintaining themselves. It's obviously going to be to their benefit. You have to look at the contract as a whole and judge whether it is for the minor's benefit. The minor, again, can choose to repudiate these kinds of contract upon attaining their majority. What about employment contracts that have not been classed as beneficial? And I guess these are really more the exception than the rule, because generally speaking, even if there are a few onerous T's and C's in terms and conditions in an employment contract, if on balance it's okay, the court will enforce that. However, there have been some fairly extreme examples of employers that really were not looking out for their employees in a meaningful sense, and therefore the court has actually struck them down at the request of the minors. Now here, the first one, I do have a soft spot for this case, perhaps because I've just seen The Greatest Showman about 53 times because my kids love it.
PT board at your service.
DeFrancesco and Barnum is the case. Again, 1890, so another one of these kind of catching bargains kind of cases. We had some minors, some girls that were engaged to do dancing for DeFrancesco. And the contracts were really quite one-sided. There were parts of the contracts that were okay. And certainly the court was at pains to say that they didn't generally think that De Francesco was running his business in a manner that was wholly unsatisfactory for the minors under his care. I mean, he certainly had educational opportunities for them available and so forth. But there were a few things in this particular employment contract that tipped it over and allowed the court to declare that it wasn't actually in the minors' best interests. What were those things that tipped it over? Part of the problem was that the minors really couldn't depend on the contract for pretty much anything at all, actually. All it was an agreement that if and when De Francesco wanted to engage them for performances, that they must perform for him and for him only. So you can see there on the 4th bullet point there, they weren't allowed to work for anybody else. So they basically had to be at De Francesco's beck and call, and they were only paid just for the performances that he asked them to render for him. So there was no wages scenario. They were just paid the fees for the actual engagements. There were other things also in this contract that were a little bit odd, a little bit unusual. They weren't allowed to marry, and they had to go wherever he sent them, basically. So foreign countries, America, you name it, he could send them anywhere. And De Francesco could end the contract at any time. So he basically had these kids at his beck and call. He didn't have to give them any engagements, and he had the added competitive benefit that they couldn't go and work for anybody else if he didn't want to give them any engagements, and he only had to pay them just for the engagements that he actually allocated to them. So obviously in those kinds of circumstances, the kids should have been at liberty to go out and work for Barnum if they wanted to pick up a bit of extra cash in order to, make a living. Really too restrictive so far as these minors were concerned. The Toronto Major Junior A Hockey Club case was another case that was more the exception than the rule. Also the case in that scenario that the contract was not in the minors' best interest, and that was a nasty little clause. It's what we would ordinarily call a reach-through clause, and we had this minor being employed by the hockey club. But interestingly, for a period of 3 years after the contract ended, if that minor that was the contracting party decided to go and work professionally for another club, then that minor would be obliged to give the Toronto club 20%, a cut of 20% of their professional fees. So that's a bit of overreaching there. Again, not in the minor's best interests, and therefore was able to be set aside by the court. So that is the issue of employment contracts. Okay, so that's probably enough for part 1, and in part 2 we'll come back and we will have a little look at contracts that are binding unless repudiated. So I'll see you in part 2. Bye guys.